Today, because the subcommittee is continuing to conduct oversight into an issue we've been following actually for more than 3 years now, going back to 2015. We have an interest in ensuring that unaccompanied minors are protected from human trafficking and other forms of abuse. We also have an interest in ensuring that these children appear at their immigration court proceedings, and we care about upholding the integrity of our immigration system. Let me begin by saying I'm concerned that some in the administration and some here in Congress misunderstand the scope and purpose of our 3-year investigation and the report we're discussing in this hearing. I would think that every single member of this panel agrees that our broader immigration system is broken. Of course, I'm not suggesting we all agree on the solutions. But the point is, that's not what this investigation and this report are about. In particular, some believe we should be addressing the push factors that drive people to come to our borders, in particular the conditions in the Northern Triangle countries of Guatemala, El Salvador, and Honduras. These are legitimate and very difficult issues. And I actually know the ranking member has been very involved in these policies, as I have been and others have been, but that's not our focus today. That's not what we're here about. We are focused on the very narrow issue of what happens to children who have already come into our country and who have been apprehended by our government. We want to ensure they are treated appropriately and that they make it to their immigration court proceedings. Unfortunately, we've seen examples of children placed with sponsors being trafficked, and right now, the best information we have is that about 50% of these children do not show up for their immigration court proceedings. This is not a partisan issue, and let's face it, there's plenty of blame to go around. The specific tragic occurrence of children being placed with human traffickers that initiated this subcommittee's investigation happened under the Obama administration. But this is a systematic problem that has continued under the Trump administration. We're interested in solving this problem. We want to ensure these kids get proper care, but also expedite the enforcement of these cases in a timely and responsible way. This is our chance to get it right. Since 2012, more than 200,000 children without legal status have crossed our borders without a parent or guardian. The law calls these children unaccompanied alien children, or UACs. These children frequently face significant trauma on their way here. And once they're here, as one Department of Health and Human Services official recently characterized it, they are, quote, in a legal no man's land, end quote. These children are typically apprehended by U.S. Customs and Border Protection of the Department of Homeland Security. Then, within 72 hours under law, DHS transfers them to an HHS Office of Refugee Resettlement Facility. At this point, HHS becomes responsible for these children's care. HHS typically places these children with sponsors, which can be their parents or other family members, but also sometimes other unrelated adults. In 2015, I learned that HHS had placed 8 of these children with human traffickers. Those traffickers then put those children, all minors, into a forced labor situation on an egg farm in my home state, in Marion, Ohio. The traffickers threatened the children and their families with violence and death. The children worked for 10 to 12 hours a day as they lived in squalor. The subcommittee investigated, and we released a comprehensive report in 2016, finding that HHS failed to do basic background checks on the traffickers who came forward to sponsor these children. We also found that no government agency claimed any responsibility for these children once the government placed them with sponsors, even sponsors who are not the children's parents or legal guardians. To this day, that remains the case, even though we believe the law gives HHS continuing responsibility, especially if they are not placed with a parent or legal guardian. HHS and DHS promised to do better. They did improve their background check process, and I commend them for that. But they still have not taken responsibility for the welfare of these children post-release. In February of 2016, after our hearing and calls from this subcommittee for better coordination between the agencies, DHS and HHS entered into a memorandum of agreement. They agreed to create a specific Joint Concept of Operations, or JCO, to document and improve their processes related to unaccompanied children. As part of the memorandum of agreement, they committed to completing that JCO no later than February 22nd, 2017. They missed that deadline. Not by a week, not by a month, but by more than a year. So we held another hearing, and after being pressed on why the JCO was still unfinished, the Department's promised to complete it by July 30th, 2018, a few weeks ago. They did finish it on July 31st. 17 months later than they had committed to do so. Unfortunately, the JCO only reiterates on paper the insufficient policies that have been in place for years through previous administrations. It's important to put processes on paper so that the left hand knows what the right hand is doing, and I'm glad they did that. But the JCO largely reiterates the status quo and does little to improve unaccompanied children's safety and ensure UACs show up to their immigration court proceedings. That said, we think it's important that the public see the JCO to understand it for themselves. We are working with the departments to get a version of the JCO that is appropriate to release, and we are waiting for the final sign-off. I'm not prepared to release it unless the administration agrees that it's appropriate to release it. I'm disappointed the departments did not take the opportunity in this JCO to address some of the problems we've all observed for years and I think are widely acknowledged. Unaccompanied children are still crossing our borders. HHS is still placing them with sponsors and losing track of them. At our last hearing, by the way, in April, HHS testified that they had started calling sponsors 30 days after placement to check on the children. I think that's good that they're making those calls, which started in 2015, apparently. But it's troubling that for the 3-month time period from October to December 2017 that HHS testified about, they said they, quote, could not ascertain with certainty the whereabouts of 1,475 children, and that 28 children had run away from their sponsors. And again, they argued they had no responsibility to know where those children are. Remember, that's just one 3-month period. We need an update on those children today. How are those calls going? What are the results? As well as determining, going forward, what we're going to do about the information we get from those calls. Yesterday, Senator Carper and I released a report on the problems the subcommittee has identified with the UAC program. It details the lack of progress from HHS and DHS in improving programs designed to care for the children, ensure their safety, and ensure they appear at their immigration court proceedings. Currently, 80,266 UAC cases are pending before the immigration courts. More than 8,000 of them, by the way, have been pending for more than 3 years. The longer these children wait, the less likely they are to appear at their court proceedings. Today, again, 53% of unaccompanied children never show up for their court proceedings, an increase of about 12% since 2016. I know this is a very difficult situation, and the gentlemen who are before us today from the administration are faced with a very difficult task. It's not easy. But these federal agencies have failed to address most of the recommendations for improving the UAC program offered by this subcommittee and the Government Accountability Office. We need to know why. We have a serious problem on our hands. These children are at risk of trafficking and abuse. When these children do not appear for their hearings, they lose their chance to argue for immigration relief, and many remain in this country illegally, which undermines our nation's immigration laws. In those cases, the judge usually enters an in absentia removal order. We may hear about that today. But most of these children are never removed. The best number we have is that about 3% of UACs are actually deported. The current situation is not good for these children or good for our immigration system. The subcommittee's report compiles our findings based on 2.5 years of oversight. I urge you to read it. It addresses a wide range of issues from problems with the JCO to the backlog of immigration court cases. As I said earlier, there's plenty of blame to go around. But I'm a lot more interested in solving the problem than making this into a partisan issue. I hope we won't do that today, because this is our chance to get this right. We're working on legislation, and I wanted to be sure we had this hearing first so that we could hear from experts from the administration as we're working on that bipartisan legislation. I appreciate Senator Carper working closely with me on this issue. I look forward to talking with our witnesses today about how we can improve this system to ensure these children's safety and ensure the integrity of our immigration system.